Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, and good morning. Welcome to the Constitutional Law Guest Lecture, Faculty of Law, Mulawarman University. Keep moving to educate and inspire through Dhamma for Indonesia. Next, let us sing the national anthem Indonesia Raya and Mulawarman hymn. All attendees is invited to stand.
Universitas Mulawarman, langkah ke masa depan. Ilmu di dada, agama di jiwa, berasas Pancasila. Universitas Mulawarman, harmoni kehidupan. Universitas Mulawarman, tonggak sejati nusa bangsa. Universitas Mulawarman Jaya. Jaya.
All attendees please to sit down back. Next, let us reading prayers will be recited by Maskur. To Maskur, time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi dan salam sejahtera bagi kita semua. Hadirin yang kami hormati, marilah sejenak kita berdoa dengan khusyuk menurut agama dan keyakinan kita masing-masing, dan izinkan saya untuk memandunya sesuai dengan tuntunan agama Islam. Amin amin ya rabbal alamin. A'udzu billahi minasyaitonir rajim. Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin. Hamdan na'imin, hamda syakirin, hamda yuafi ni'amahu wa yukafi'u mazidah. Ya Rabbana lakal hamd, ya Allah, ya Tuhan kami. Tiada kata dan rasa yang pantas kami haturkan padamu hari ini selain syukur kami padamu atas segala nikmat dan bisa hadir bersama untuk mengikuti kegiatan quiz lecture, PBL training, and mood card for students. Untuk itu ya Allah, ya Rahman, ya Karim, jadikanlah acara kami ini sebagai acara yang Kau ridhoi, yang membawa barokah, rahmat, taufik dan hidayah-Mu bagi kami semua. Ya Allah, Tuhan yang maha bijaksana, Engkau maha kaya dan maha alim. Kami sadar bahwa ilmu yang kami miliki sangatlah kurang. Kami sangat membutuhkan tambahan ilmu dari-Mu ya Allah, untuk bekal pengabdian kami dan menambah kualitas diri kami, agar kami mampu mengemban tugas dan tanggung jawab yang diberikan kepada kami untuk kebaikan dan kemaslahatan bagi masyarakat, bangsa dan negara kami. Rabbana taqabbal minna innaka antas samiul alim wa tub alaina innaka antat tawwabur rahim. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzabannar. Subhana rabbika rabbil izzati amma yasifun wa salamun alal mursalin walhamdulillahi rabbil alamin. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Mashkur. May God bless us all. Amen. Well, first let us pray and thank God because for His mercy and guidance, we can join the series of Constitutional Law guest lecture this morning. Next, the speech from Dean Faculty of Law Mulawarman University, Mahendra Putra Kurnia. Time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, selamat pagi. Bahwa pada pagi hari ini seperti yang disampaikan oleh Master of Ceremony, ini adalah sesuatu yang kita harus bersyukur. We have to thanks to God and our Prophet because berkat rahmat dan hidayahnya kita bisa bertemu dan berjumpa di majelis ilmu yang mulia ini, karena majelis seperti ini, forum-forum seperti ini adalah forum yang memang dibutuhkan untuk menambah keilmuan dan pengalaman bagi kita semua. Tentu saja pada pagi hari ini kita kedatangan tamu spesial ya, tamu spesial dari jauh dari we have a guest from far away from here. Beliau adalah Mr. Sascha Hardt. Beliau kemarin berangkat dari Jerman menuju ke Samarinda. Jadi harus from his hometown in Aachen going to Düsseldorf and going to Frankfurt, Frankfurt to Singapore, Singapore to Jakarta, and Jakarta to Balikpapan, and Balikpapan to Samarinda. It's a long journey, a long trip for ini semua untuk Sascha did it to meet all of you, untuk bertemu dengan kita semua di kegiatan pagi ini. Ini sebenarnya menjadi bagian dari kerjasama. This is the part of cooperation between our faculty dengan University of Airlangga. Jadi ini merupakan bagian dari salah satu rangkaian kegiatan kerjasama antara Fakultas Hukum Universitas Mulawarman dengan Fakultas Hukum Universitas Airlangga dan University Law Faculty of Maastricht University. Karena kita mengadakan beberapa kegiatan kerjasama internasional yang salah satunya diinisiasi oleh Universitas Airlangga, Fakultas Hukum bersama dengan Maastricht University, dan kita menjadi bagian dari kerjasama itu. Dan sekali lagi, we have to say thanks to Maastricht University and Airlangga University who represent by Mr. Radian. Pak Radian ini adalah dosen dari Fakultas Hukum Universitas Airlangga Surabaya yang memberi kesempatan kepada kita untuk mengadakan kegiatan seperti yang kita lakukan di pagi hari ini. Jadi ini sekali lagi ini merupakan this is the part of our cooperation with Maastricht University, Law Faculty, Maastricht University, dan Fakultas Hukum Universitas Airlangga. Setelah ini mungkin kita akan banyak lagi beberapa kegiatan-kegiatan dalam 2 hari ini. Nanti siang ada PBL for lecture, besok ada practicing PBL in the class, dan siang harinya ada moot court for students. Jadi rangkaian kegiatannya sangat panjang selama 2 hari ini. Semoga semua kegiatan ini bisa kita selesaikan dengan baik. Sekali lagi, welcome to Samarinda, Mr. Sascha and Mr. Radian. Terima kasih atas kesempatan dan kehadirannya di Samarinda pada pagi hari ini, supaya yang akan mencoba membantu untuk to translate atau make a summary for Sasha's presentation. Jadi kalian nggak usah khawatir kalau tidak terlalu mengerti apa yang disampaikan oleh Sasha nanti. Kita ada Pak Sukri yang sama-sama he's come back from Amsterdam just only for this meeting, so he will come back to Amsterdam again after this after this meeting, after these events. Jadi nggak usah khawatir nggak mengerti apa yang disampaikan oleh Pak Sascha, Mr. Sascha, karena Pak Sukri akan membantu kalian mengerti mengenai apa yang akan disampaikan oleh Mr. Sekian, terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Thanks to Mahendra Putra Kurnia for the speech. Next, this event will be guided by moderator Syukri Hidayatullah. To Syukri Hidayatullah, time and place is yours.
Selamat pagi, good morning, ladies and gentlemen, teaching staff in Faculty of Law, Mulawarman University, and students of Faculty of Law. It's such a pleasure to meet you here this morning because we are going to have a discussion with Sascha, and we have to say welcome to Sascha. Yeah, I hope you enjoy the city.
Thank you very much. Thank you very much for
course.
having me.
Yes, we also very enjoy to having you here. Yeah, we can't wait to hear what you will discuss this morning.
Thank you.
Ya, and selamat datang Pak Radian dari Surabaya. Jadi Bapak Ibu sekalian dan mahasiswa, sebelum kita mulai diskusi ini, saya akan bacakan singkat your curriculum vitae based on the internet. Just a brief information about your research area. Sascha menulis PhD tentang parliamentary immunity, kekebalan parlementer di Uni Eropa dan di parlemen-parlemen di Eropa pada tahun 2013. Beliau juga pakar di area tentang perbandingan hukum konstitusi dan hubungan antara proses-proses politik dan pembangunan di dalam hukum konstitusi. Yeah, so without no doubt, I guess from this information we know that Sascha is very expert in the terms of law and constitution in Europe and also across the country. So kita akan bicara dan mendengarkan dari orang yang tepat. We are going to learn from the right person in the right time because yes, we can't wait to see and to hear what is the topic today. Kita akan sabar untuk mendengar dan melihat topik dan pemaparan apa yang akan disampaikan oleh Sascha. Berikutnya akan saya sampaikan, I'm going to tell you about the duration of this presentation. Kita tidak akan lebih dari 2 jam. We are not going longer than 2 hours. Jadi by now is 10:30, sekarang adalah pukul 10.30. Sascha akan menyampaikan presentasinya. You will deliver your presentation like 30 or 45 minutes. And then we will end this presentation like before 1 o'clock this noon. Kita akan menyelesaikan presentasi ini sebelum pukul 1 siang. Setelah Sascha memaparkan presentasinya, after Sascha deliver his presentations, then we are going to have Q&A session. Kita akan diskusi, pertanyaan dan jawaban, dan jangan sia-siakan, you don't have to waste this opportunity. Jangan sia-siakan kesempatan ini. Raise your hand, you can speak bahasa, you can speak English, and tanya sebanyak-banyaknya kepada Sascha. You can ask anything. Yeah, anyone you want to ask about constitutions or law in general, please raise your hand and ask to Sascha. Okay, without further ado, Sascha, please, you may begin your presentation.
Thank you very much, Pashukli, for the kind introduction. Thank you very much also to Pamahendra and to Mulawarman University for having me. It's a great pleasure to be here. It's also a great pleasure to finally be able to travel again and to come to Indonesia. And of course, it has been a long trip, but I always enjoy being here. And it is my first time in Kalimantan, my first time in Samarinda. So I'm really very happy to be here and have the opportunity to deliver a short lecture this morning. I have been asked to talk to you about constitution making or about constitutions in general. Before I start, do you understand me in English, or do you understand me better in English if I try to talk a little bit slower, or should I rush through it and make more time for the summary? What would you, a bit slower, okay.
A bit slower, okay? So no translation, just a bit slower. Agak pelan saja.
Okay.
Tanpa translasi. Okay.
I understand. So we made an agreement that after I finish, Pashukli is going to give a briefer, I guess, summary of the presentation as I gave it for anything that might have been lost in translations. But if you have any questions or if anything is unclear, also while I'm speaking, in Maastricht we do PBL, so lectures are usually interactive. I ask questions, you scream if you don't understand something, so don't feel afraid to raise your hand and ask questions also during the lecture. I don't mind. Actually, I appreciate having a conversation. So today let's talk about constitution making, or about what constitutions are for and what they do. And therefore the title of the presentation is Concepts, Contexts and Complications, also because it sounds nice. But I'm going to show you briefly what I intend to do in this what do I have, 45 minutes, so let's see if that works. First of all, let's reflect together very briefly. I understand that you all have taken a course on constitutional law, so this shouldn't be very new to you, but it's always good to recapitulate a little bit. What are constitutions for? What are their roles and functions in a society? And what is constitutionalism? I always find it important not just to talk about the constitution as a document or as something abstract, but also constitutionalism as an idea, as a concept. Because I think the mere fact of having a constitution doesn't say very much. Every state has one, North Korea has one, but largely doesn't abide by it. So constitutionalism is an important add-on, and I'm going to. A weird kind of animal, they are not always see constitutions in context. And I'm going to talk a little bit about the context in which constitutions live. And then, of course, the interesting part, in making or amending or understanding or interpreting constitutions, we are faced, and judges are faced, and societies are faced with a couple of problems, dilemmas, complications. And I'm going to just give some brief examples, and I hope to find a suitable Indonesian example as well of these complications. And lastly, I'm going to do something which is a little bit risky, because I'm very decidedly not a scholar of Indonesian constitutional law. So all I can give you by way of an illustration is an outsider's perspective. But sometimes outsiders' perspectives are quite useful also in studying certain problems, because you don't get lost in your own cultural context, because it's not mine, so I have a very outside view on this. And of course I've read a lot on Indonesian constitutional law in the course of the past couple of years when we have been running this project. So maybe I can say something which is interesting about one particular, I find fascinating aspect of Indonesian constitutional law, which is Article 33 of the Indonesian Constitution. So I'm going to use that towards the end of the presentation as an illustration or as an example. And you can tell me if I'm totally wrong about it. Feel free to do so. And I'm always happy to have a discussion. Now, first of all, what's the role and the meaning of a constitution in the state or in a society? What are constitutions for? Why do we have one? Now, if you look at the world, as I said already, every state does have one, but not every state follows the constitutionalist model. So not every state affords their constitution the same importance or the same role in the legal system. But as a very base notion, a constitution is essentially a conduit between the legal world and the social world surrounding it. So a constitution is, in very basic term, yes, a legal instrument on the one hand. It's at the very top of the legal system. It is the thing that defines and delineates the legal system. But on the other hand, the constitution is also the link between the legal world and the state and the society in which this whole legal system lives. Because law, and Pashukri is the expert on this as a social legal scholar, law is really a social phenomenon if you look at the reality of it. We have law in the books, we have the rules, but in reality law is nothing without the people that either abide by it or don't abide by it, or interpret it or have a certain view on it. So ultimately law is a social phenomenon. And the constitution is the link between the life of a group of people, which we call the state or the population of a state, on the one hand, and the legal system that can be studied basically as an abstract subject on the other hand. So that is one function that constitutions have, and we shouldn't forget that this makes constitutional law, at least for a very good part, not only a legal subject, but also a subject of sociology or anthropology maybe. Now, if we look at constitutional practice, what constitutions do and what they look like, we see a couple of basic functions. You all know them. First of all, constitutions, whatever their form may be, lay down a couple of fundamental rules for the life of a state. Constitutions define, for example, they define what the territory is. They define who are the subjects of the legal system, who are the Indonesian people, for example. It could be everybody living in a certain territory, everybody holding a certain nationality, everybody belonging to a certain ethnicity. States have different solutions here, but that is one of the things. Also, constitutions usually define institutions of state. There shall be a president, there shall be this and that house of parliament, and then importantly their competences, that's called attribution, shall be the following. That's normally the content of a constitution. And then third, regulating hierarchies and regulating relationships between all the components of a state. So what is the relationship between you as an individual or citizen of Indonesia and your state? Do you have certain fundamental rights, for example, against the state? Do you have certain duties? Or do you have options of participation, like the right to vote, etc.? Normally, these are functions of the constitution, along also regulations of relationships, of course, between the state institutions. But next to that, constitutions are also very important symbols of the state. Think of how the American people identify with that document in almost a religious way. So it is not only a legal thing, it is also an item of national identification. Very often, constitutions even stipulate, for example, what the flag looks like and what the national anthem is that you just sang so beautifully at the beginning of the session. So it's really also an item of national identification. And this brings us to an important point. Constitutions are not only descriptive of reality, they are to a very large extent aspirational projects. So constitutions don't only say what is, they also always give a vision of what the drafters of the constitution intend the state to look like eventually. So it is also a future-oriented kind of thing. On the one hand, it constitutes, as in creates the state, but it also describes a certain vision that the state may not at present live up to yet, but it shows what the drafters had intended. And when we later speak about constitutional developments and amendments, we should bear in mind that constitutions are never finished. They always develop in a certain direction, and they can also change a good deal depending on the fashion of the day and the legal disputes that you have talking about. So earlier with one of your colleagues, I had a conversation about the omnibus law, for example, or certain developments that are currently going on. So constitutions are never set in stone, even when they are literally set in stone. So people have different ideas about what they should look like in the future. Constitution itself is a thin concept. There is no strict rules that are universally recognized on what a constitution needs to look like. For example, it can be unwritten in large parts. Look at the United Kingdom, which does not have a constitution in one document, but nobody would seriously claim that the United Kingdom has no constitution. Of course there are rules, they just come in different forms and shapes. Some of them only in convention, but these conventions are hundreds of years old, so they are really authoritative. Constitutions can be uncodified. So for example, you have constitutional rules spread out across a number of documents. Look at Sweden, for example, which doesn't have a constitution in one document but several. Constitutional rules can also be contained in, constitutions can contain items that are not of constitutional importance, and vice versa. There can be constitutional law outside of the constitution. Think of electoral codes. Very often electoral rules are not laid down in the constitution itself, but still they are of such importance that they have constitutional rank. So formal criteria are not criteria by which we can recognize or distinguish what is constitutional and what is not. It is about what we attribute to a constitutional rule. Then, very importantly, these contexts. When we think about making constitutions, this never happens in a vacuum. It never happens that somebody who has no attachment to any historical, political, social situation sits down in an armchair and thinks about what a new constitution should look like. Constitutions are always created in certain historical or political circumstances, such as moments of decolonization. Now, your own country used to be colonized for a very long time by various powers, for a long time the Dutch. And when the Indonesian constitution was made, it was made while the country was still struggling for independence. And of course that has an impact on how the constitution is made. Often constitutions are made in war times or immediately after war has ended. Think of my own country's constitution in Germany, which is a typical case. I will give you an example from that later. Sometimes constitutions are made or remade in moments of deep political crisis. Just right now, or a couple of months ago, in the Latin American country of Chile, they tried to give themselves a new constitution. It ultimately failed in a referendum, but the idea was that the constitution they have creates a very unfair situation for large parts of the population, and therefore it might be a good idea to have a new one. Ultimately, the people didn't accept it, but you see that it doesn't have to be a war or a decolonization situation. It can also be a moment where large parts of the population come together and think that the constitution is not working anymore. Constitutions are influenced by social and geographical circumstances. For example, Indonesia is a very heterogeneous state. People belong to different language groups, different ethnicities, have different traditions, different religions, and still they need to live together in one state. And of course, the constitution has to cater for that somehow. Territorial things might have an impact. If your country is very complicated in terms of territorial divisions, natural resources are allocated unequally and so on, maybe your constitution should contain rules on what to do with these inequalities and differences in distribution. That shapes what the state looks like. Culture and traditions, of course, play a very big role in how constitutions are made, because there's always a problem, a dilemma between the vision of what your ideal state that the drafters have in mind looks like and the realities that they have to work with. So if certain traditions, for example, of religion exist, and even though somebody might have the idea that the life of a state should ideally be secular, you have to work with the people that there are. So the constitution should maybe incorporate certain traditional aspects. And the Indonesian constitution is a very good example of how the drafters try to incorporate these ideas and make it work for virtually everyone in the state. So how can we incorporate the traditional life of the territory that we're governing with the idea of a state that we're formulating? That is the troubles that constitutional drafters face when setting up a constitution. And that is the trouble that constitutional interpreters and ultimately everybody who lives and participates in the legal life of a state faces when working with these constitutional norms. Now that's very abstract, but have a look at some examples. So for example, the United States Constitution very famously is a constitution made not only for the new American state that they founded a little more than 200 years ago, but it is also a constitution explicitly made against something. It was a constitution made against colonialism, against the old monarchical system that they had under British rule. So the constitution therefore emphasizes freedom. It emphasizes the limitations of state power over the individual. Very famously, Article 1, Section 8 of the United States Constitution gives the US Congress a certain number of powers that they have, that they can make laws about, and everything that's not in that article can be regulated only by the individual states, and everything that they can't regulate is simply freedom for the individual. So there are many things that the state cannot do to you, and that's a very important function of many constitutions, but in the United States understanding, it is one of the most important functions of the Constitution to guarantee, by way of the Bill of Rights that has been added to the United States Constitution, individual freedom against the state. But the making of the US Constitution is quite some time ago, and since then a lot has changed. But changing the American Constitution is extremely difficult. So does the Constitution still live up to the requirements of this day and age? If you think about the debate around everybody's right to own a firearm or a weapon, which causes a lot of trouble in the US, it seems to be somehow so this shapes the debate very much. Or think of Germany. Germany was a constitution made after the Second World War, after the country had perpetrated what is probably one of the greatest set of crimes in human history. So you can read the entire constitution of Germany as a never again project. The main aim, if again, for example, education cannot be regulated at national level, because the drafters understood education is a tool for indoctrinating people if it is in the wrong hands, so it should better left to decentralized levels. Article 1 of the German Constitution speaks about human dignity. Whatever the state does must respect human dignity. Now, that's of course a very open context, but it's sort of the headline of the entire project. You only understand this if you understand the historical context in which the constitution was made. Think about Gaullist France. Democracy wasn't working particularly well, and there was a war situation, a colonial war in Algeria. They brought President de Gaulle back and asked him to be president again, and essentially he demanded that the constitution be streamlined and that democracy and parliamentary rights be limited as a condition for him to come back to power. We see the results today. The French parliament is uniquely limited in what it can do, what it can legislate. If you compare that to other countries, a very weak parliament, you might say. Think of Indonesia. Indonesian constitution was made during an independence struggle and in a time period when it was far from clear to everyone in the country why this array of, I think, about 17,000 islands should be one country in the first place. You had different languages, different religions, different social traditions. The main unifying factor at the time was that it had been ruled by the same colonial powers for a long time, but before that it had already belonged to different states. So one important aspect in making the Indonesian constitution back in the day, and to an extent still today when interpreting it, is unifying the country, making sure that this array of territories and population groups grows together and is able to collaborate. So this independence struggle and the state building the visionary capacity of the constitution was extremely important in the Indonesian case. So context always matters. And we have to remember those contexts when we consider the problems in our day-to-day life of constitutional law. So constitutions or constitutional scholars and constitutional courts also, when they discuss complicated cases or complicated questions in the political life of a state, always face a certain dilemma, and constitution makers face the same dilemma when drafting the constitution. I give you 3 examples. First, the example of amendability, continuity, and interpretation. On the one hand, a constitution wouldn't be very powerful if it is super easy to amend. If you can, if the parliament could just change the constitution completely at a whim, then what is the constitution good for if it doesn't stand? So constitution needs to guarantee a certain continuity, and therefore it speaks to reason that it should be hard to amend. How hard is an important and difficult question, though, because social context and the needs of the people change over time. The drafters of the US Constitution made theirs very, very hard to amend. There have only been 27 amendments in a little over 200 years of history, which is very, very few. And the last one is already, many decades ago. So it's hard to amend, but at the same time, that makes it extremely hard to adapt to modern circumstances. So the whole firearms debate, for example, or the whole issue that they currently have about Roe and Wade and abortion and certain social rights, extremely hard to do something with it in constitutional terms. Or think about the same question in terms of flexibility versus the possibility of abuse. So when constitutions are drafted, especially to enshrine democratic systems, it's often a good idea, and many constitutions have this, to introduce term limits. On the way here yesterday, I had an interesting discussion with one of the colleagues from Mulawarman about a current debate in Indonesia about the term limit of the president. Currently, I understand the president is limited to 2 terms in office. 3. Is it 3? But he wants a third. He wants a third one, I understand. So there are political tendencies to change that rule. Now there may be circumstances, and I'm not going into Indonesian politics, and I have no opinion on this, but it is theoretically possible that limitations or changes to a term limit might be a desirable option. On the other hand, if you make it too easy to change, obviously it's susceptible to abuse. And very often this causes leaders, authoritarian leaders often, to go to great length. For example, the president of Turkey has had his parliament change the constitution to allow him to have extra terms. The Russian president, well, in one of the latest, one of the last episodes, he stepped down, installed a proxy as a president for 4 years, and then ran again. But then the constitution was still amended to give him basically the possibility to sit forever. And you see what is happening in that country right now. So making the constitution flexible might be a desire, but making it hard to amend is also quite reasonable if you want to maintain the stability of at least a democratic system. So it's good to guard against such tendencies, even if that might go against the wishes of some to have extra political terms. Think of the question of constitutional review. Now, in my own country, Germany, the system of constitutional review is very strong. We have an extremely powerful constitutional court, which can destroy laws if they are found to be unconstitutional. And interestingly, the Constitutional Court is probably the most popular legal institution in the whole country. More popular than the government, more popular than the parliament, more popular than the federal president, because they usually have the appearance to act in the interest of the people when they defend people's rights against political decisions. On the other hand, you might say, most countries, but who are basically appointees and very often lead a very unchecked professional life. The institution should be the most legitimate view of what the meaning of the Constitution is. So ultimately it boils down to culture. Do we trust our politicians more, or do we trust our lawyers and judges more? In Germany, certainly after the war, we don't trust politicians. We trust, if anything, we trust judges who have been schooled in democratic constitutionalism. In the Netherlands, they trust politicians more because politicians are closer to the people and judges are seen as elitist and somewhat removed from the people. A last complication that I would like to discuss, clarity of norms. On the one hand, constitutions must be clear to everyone. So constitutions must be broadly applicable, they must be future-oriented and all that, they must present a vision, but they also must be concrete and tell you what the matter is, tell you what the rule is. And at the same time, be broad enough to incorporate, many political options which the state then later can take. And that's super difficult to reconcile and to do both at the same time. Think again, Second Amendment rights of the Constitution, which is not very clear. It said a well-regulated militia and so on. You can read the Second Amendment. It's basically a provision that stems from a time when power wasn't, or the use of power wasn't consolidated in the hands of the state just yet, and it was really important to have citizens under arms if necessary. Now, those days have long gone. Still, the provision is there. It is not very clear. It would be desirable to clarify it, but it is hard to amend. Think of, and I'm going to go a little bit deeper into that in a minute, Article 33 of the Indonesian Constitution, which talks about the use of natural resources of the state. And it says famously in the article that the state should handle natural resources on the basis of the principles of a family. Now, what exactly does that mean? What kind of family are they talking about? That's not clear to everybody. And even if it is clear to everybody, it might have meant something different in the 1940s than it means in the 2020s. So clarity of norms is an issue. Constitutions must be clear, and open at the same time. So that these are things that are very hard to reconcile with each other. And then briefly, as I promised earlier, the notion of constitutionalism. Constitution itself, as I hope I have explained now, is a very thin concept. Everybody can have a constitution because the only thing you need for it is to have rules which define, attribute, and regulate. But constitutionalism is more than that. Constitutionalism is the base notion that state authority is not only constituted, but also limited. Limited by legal norms to which state organs and representatives also have to abide. So state action is only legitimate if it is conditional and in compliance with certain norms. But the extended notion of constitutionalism goes a little bit further. Limitation of state authority must be entrenched. So there must be a hierarchy of legal norms, and that the powers must be separated, but this doesn't in itself mandate a democratic form of government. In constitutionalism nowadays, we think of democratic states normally. So we have democratic constitutionalism, constitutional democracy. Law ultimately comes or is legitimized by the people whose will is expressed through democratic processes. So we have the rule of law, state is bound by law. We have democracy, ultimately the source of the political will and the content of law is the people. And lastly, against democracy, if you want, you have fundamental rights. Even if the majority wants something, there are limits to what the state can do to individuals. For example, certain basic rights must be given to every individual, also to minorities, also to groups which everybody in the majority dislikes. So fundamental rights are the third angle of the triangle. So you have the state institutions being bound by law, you have democracy as the source of political will, and you have fundamental rights as a third cornerstone, which might even go against the democratic principle. And this triangle together formulates the principle of democratic constitutionalism. Now this turns the thin definition of a constitution simply being a set of rules that regulates the state into a thick concept which gives the state a certain spectrum in which there's still a lot of possibilities and a lot of choices, but certain things also fall outside that spectrum. You can't abandon fundamental rights. You can't abandon democracy, and you certainly can't abandon the rule of law altogether without losing constitutionalism. And that does something, for example, to what you can do with unwritten social norms. Can the Constitution delegate power to, for example, local wisdom? Can there be local unwritten norms that derogate from constitutional law and from the legal system as mandated by the state? Well, yes, but only within limits. Because the content of the law must be reasonably clear. The legal norms should be at least in a certain hierarchy throughout the entire polity governed by the Constitution. Rules that contradict constitutional norms cannot be valid. So, for example, you can't have local rules which violate fundamental rights if the fundamental rights are an item in your Constitution. And the capacity of a working system of constitutional law to accommodate sort of these traditional norms, local norms, religious norms, whatever, is therefore limited. It is not impossible to do so, and I think Indonesia is a good example of how that can work, but it is always walking a very tight rope between a system which can adhere to constitutionalism and a system which has tensions with this concept of constitutionalism. And before I finish, I would like to give you this little illustration, as I warned you earlier, from complete outsider's perspective. So I don't claim to be the expert on this, but this is an interesting illustration that I read about from your own polity. Because historically, and then especially during the Suharto era of the Indonesian state, Indonesia very clearly hasn't subscribed to reformation in the late 90s, early 2000s, looks very different. And it now very clearly and very explicitly, and also in the development plans very explicitly, aspires to the full implementation of constitutionalism. One of whose corollaries, by the way, is the project in which we have been working, which has the idea of promoting constitutionalism and rule of law as one of the cornerstones. Yet, if you look at what the constitution looks like, there are still remnants of a time in which the idea of constitutionalism fell uneasy with the drafters and the political makers of the Indonesian state. And I think, so this is the reiteration of the pyramid. I think in Article 33 of the Constitution, you can find a good example. Let's have a brief look at Indonesian constitutional history. So some of the drafters had ideas and writings that were very explicitly contrary to what I just explained about constitutionalism. So, for example, one famous intellectual who was one of the builders of the Indonesian constitution was Mr. Supomo, who wrote, and this is a translation which I didn't make myself, and I hope the translation is accurate, that there will be no need in the constitution for Grund- und Freiheitsrechte, which is a German term for fundamental rights, of individuals against the state, because individuals are nothing than organic parts of the state, having specific positions and duties to realize the grandeur, the greatness of the state. Therefore, fundamentally, there is no dualism between state and society. There is no conflict between the structure of the state and the legal structure pertaining to individuals. There is no dualism of Staat und staatsfreie Gesellschaft, state and society free from state intervention. Now, if that is so, the meaning is that the moment that somebody has an opinion or does something which is contrary to the current political opinion of the government, they fall out of the system and they have relinquished all rights. That is, of course, not only at odds with history. Constitutionalism is also a very young phenomenon. So we see that it is a relatively recent development in this country and in other parts of the world as well. Supomo's ideas are, however, not sort of Indonesian provincialism or so. No, quite the opposite. They were imported. Because where did he study? Supomo studied in Leiden in the Netherlands. He was a student of Mr. van Vollenhoven. And that man, again, who had a great impact on the Indonesian legal system, was a student of the German idea of the national spirit, the Volksgeist. National spirit as the embodiment of the spirit of the people, sort of a religious, an idea quite similar to a religious idea about, that the people are one and there cannot be any difference within the people. Law is not the result, he thought, of legislative activity, so positive law, but law is the result of sort of some ethereal national spirit. Now, if you have that thought at the basis of your state, that's very dangerous, and it's completely at odds with constitutionalism, because it is not a good sign for anybody who is in a minority or who is individually at odds with the state. It doesn't reconcile with fundamental rights. It has changed, huh? And I think for Western scholars of Indonesia and many other countries with a similar colonial past, it is a good advice to not look at those countries with a paternalistic view, and to treat such phenomena as the thinking of Mr. Supomo as something that is sort of uncivilized or that is something provincial or parochial, because where did these ideas really come from? Well, they really came from the West and from the colonial powers, who adhered to such principles themselves until not very long ago. So that only on the side. The result, however, in Indonesia was quite impactful, because to this day it is sometimes so that you see a dichotomy between positive law that is made by the institutions in Jakarta and the implementation that it has in practice. So law is sometimes seen as something a little bit alien, and something that is really different from what you see happening on the ground. And this is also a historical remnant. In the Suharto era, you had law on the books, which looked quite normal to the rest of the world, and the law as it was applied and as it was implemented, because it was an authoritarian regime, like you see in Russia today or in Turkey, for example. So there was legal formalism, yes, but no actual remedies that individuals could effectively enforce against the state. Now then, of course, you had the period of constitutional reforms, the amendments, the establishment also, not least, of the Constitutional Court, a lot of declarations of intent which are gradually enforced, and a lot of movement in Indonesian constitutional development. But there still remain some tensions between the setup that was influenced by non-constitutionalist ideas like Supomo's ideas and the implementation, the full implementation of constitutionalism today. And Article 33, and I'm going to finish with that, is a very interesting example of that. Have a look at the text. The economy, says Article 33, paragraph 1, shall be organized as a common endeavor based upon the principles of the family system. Now that in itself is an interesting norm, but a very vague one. Everybody can, in principle, have completely different ideas about what that means. The article goes on to talk about sectors of productions which should be under the powers of the state, which also is open to interpretation. Does it mean the state has to manage natural resources itself, or the state can license it, or the state shall have the power to privatize it, or what does it mean to be under the powers of the state? Recognizing the difficulty of this, the article was amended, actually added to in 2002, giving it another 2 paragraphs, number 4 and 5. Organization of the national economy shall be conducted on the basis of economic democracy, whatever that is, upholding the principles of togetherness, efficiency with justice, continuity, environmental protection, sorry, that's a typo in the slide, self-sufficiency, and keeping a balance in the progress and unity of the national economy. Now, it added a lot of principles, all of which are individually open to interpretation again. Further provisions relating to the implementation are then delegated in paragraph 5 to statutory law. Did that help? Not very much. You saw 2 rulings later on by the Constitutional Court which come to completely different interpretations of what Article 33 actually means. So, can any specific obligation or maxim for action be read into these principles of the family system that the article still today talks about in paragraph 1? I'm not sure. The Constitutional Court is also not sure, or at least it was sure of opposite things in 2 different rulings in 2003 and 2012 respectively. In one, they essentially said it should all be managed by the state, and in the other, it essentially said it should all be privatized, or based on the same article. Now, that is not so strange. It happens with a lot of constitutional provisions in a lot of countries. And it illustrates what I said earlier. They must at the same time give a vision and be clear, and be open to interpretation and adaptable to circumstance. So what does it tell us as a bottom line? What does it tell us as a lesson? Ultimately, constitution making and constitution development is never finished. You are never going to live in a system that is that is perfect, or at least that isn't going to change anymore because circumstances evolve. That is quite normal, and we should not despair about it. Also, the success or failure of a constitutional system depends on many different factors. It depends, I think most of all, on the willingness of all the participating actors and institutions, the parliaments, the political actors, the courts, and not least the people, to participate and maintain the system and not to uproot or abuse it. You can never have any constitutional system against the people. If the people are not democratically minded, ultimately democracy is going to erode. If the people don't develop a civil society which enforces their fundamental rights have a very difficult position in the state, and so on. Yet, what is also important is that the constitution is not completely irrelevant for this reason. It has to maintain a good balance always between an openness and a spectrum of possibilities, and limiting these possibilities so as to prevent extremes or outliers to the non-constitutionalist extremes. Where exactly that balance is different per country. It will be a different position of balance for Indonesia than it is for Germany, simply because there are different histories, different contexts, different people living there, and different ideas. So let's be happy to live in a very diverse constitutional world. Thank you very much for your attention.
Thanks, Sascha. Terima kasih. Saya akan summary, very brief. Saya akan sampaikan dengan singkat inti dari the substance of this presentations from Sascha. So, the bottom line is, pada dasarnya kita sudah bicara tentang konstitusi, ya. Dan dalam skala yang besar, secara umum, in general, Sascha bicara tentang konsep, 3 variabel, konsep, konteks, dan complication. Ya. Pertama kita bicara konsep saat kita mempertanyakan tentang fungsi dan arti dari konstitusi. Dikatakan Sascha, konstitusi menghubungkan negara dengan sistem hukum, ya, dan juga menjelaskan prinsip fundamental tentang negara, misalnya teritori, institusi, simbol, ataupun visi dan cita-cita negara. Lalu yang kedua bicara tentang konteks, dijelaskan oleh beliau bahwa konteks itu terbentuk dalam certain realities, ya, dalam kenyataan tertentu yang kemudian dielaborasi menjadi 3 hal. Yang pertama adalah menurut sejarahnya, yang kedua adalah keadaan sosial dan geografi, dan yang ketiga adalah budaya. Itu konteks pembentukan konstitusi di sebuah negara. Tergantung, karena ada perbedaan realita, maka perbedaan konstitusi di setiap negara juga eksis. Yang ketiga adalah bicara tentang complicated, ya, tentang rumitnya sebuah konstitusi itu ditegakkan di negara. Karenanya ada dilema yang berasal dari 3 hal juga. Yang pertama adalah kalau konstitusi itu bisa diamandemen, maka dipertanyakan kejelasan normanya. Oleh karena itu, interpretasi, ya, atau penafsiran terhadap konstitusi dipertanyakan juga keberlangsungannya, the continuity-nya. Yang ketiga, oleh karena kebutuhan amandemen ini muncul, maka ada yang dinamakan dengan constitutional review, ya, tinjauan konstitusi. Ini dilemanya. Bisa dikatakan we are talking about legal certainty, kepastian hukum. Kalau sudah ini clear, maka kenapa dirubah? Ya. Nah, kemudian beliau masuk kepada kasus konstitusi di Indonesia, and then we going deeper into the case of Indonesian constitutions. First of all, menurut Supomo, and this is very interesting, ya, no need for basic right and liberty. Saat kita bicara tentang hak asasi, kata Supomo, kita nggak perlu bicara tentang hak-hak dasar dan kebebasan. Karena people, because individual, are nothing than organic parts, tidak lebih dari bagian organik dari sebuah negara. And then why Supomo say that? Kenapa Supomo bicara seperti itu? She was in Leiden, and he was in Leiden, and he inspired by Van Vollenhoven, and then we talk about the Volksgeest, yeah, and then we talk about Indonesian customary law or adat law that exceeds yang sudah ada way before the constitutions form. Hukum adat sudah ada jauh sebelum konstitusi Undang-Undang 45 dibentuk. Oleh karena itu, maka bagi beberapa orang di Indonesia atau bagi sebagian besar, for the most part of Indonesian people, hukum formal itu adalah dianggap sebagai asing. Formal law considered as an alien. Because they already have an adopted adat law, customary law, which is way more flexible and informal way. Ya, hukum adat lebih fleksibel dan informal. And unwritten, tidak tertulis, tetapi langsung dipraktekkan, but it is practically by the people of Indonesia. Ya, tradisi, kebiasaan, customary, adat law, far way different, jauh berbeda dengan formal law yang dibentuk oleh negara. Dan secara spesifik, and with more specific, Sascha goes down into the case of Article 33, Pasal 33 Indonesian Constitutions, when he asked about the familial or kinship system, according to the Article 33. What is that? Apa itu sistem kekeluargaan yang ada di Pasal 1 ayat 33? Sorry, yang ada di ayat 1 Pasal 33. Lalu kemudian natural resource controlled by the state. Kekayaan alam dikuasai ya oleh negara. Perhaps we can interpret like this, Sascha, that the state monopolized the natural resource. Ya, so seperti ini. This is my oil and gas. This is my coal mining. This is my land farmer. This is my natural resource. I'm sorry, this is my natural resource. That's what the state say. Ini adalah sumber daya alam saya. This is belong to me. That's what the state say according to our constitutions. And then what for? Lalu untuk apa? Itu beberapa contoh yang tadi dikatakan oleh Sascha. Dari secara global kita bicara tentang 3 hal. In general, we have discussed about 3 items. First is the concept, and then we're going down to the context, and then we're going down into the complicated system of constitution. And he given the example of our constitutions, Indonesia, Undang-Undang Dasar 1945, with a specific case in the Article 33 about economy and democracy. And that is the summary of this lecture, guys. Itu adalah ringkasan dari kuliah tamu hari ini.
Thank you very much. Thank you very much.
Thank you very much, Sascha. You're welcome. Okay, we will go into the first session of Q&A. For the first 3, bagi 3 pertanyaan pertama, please raise your hand and you can ask in any language. You can, yes, please. Ada dibawakan sama Mas Mahdan.
Tes. First of all, mungkin maybe I want to say my sorry because I want to questioning in bahasa.
Sure.
Mungkin.
I'm sorry, what is your name?
Oh yes. My name is Randi Ismail.
Sorry?
Randi Ismail, Remus. Ya. Yeah. Randi.
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 Okay, Randi.
I am from International Law 2019. Mungkin pertanyaan saya berhubungan dengan bagaimana suatu konstitusi itu dibuat dan diamandemen. Indonesia sendiri itu memiliki bentuk konstitusi yang rumit seperti yang telah disampaikan tadi, berbeda kontras dengan United States Constitution. United States Constitution mungkin sifatnya lebih kaku, lebih sulit dirubah, oleh karena itu juga memiliki resiko-resiko tersendiri dalam amandemennya. Tetapi bentuk fleksibilitas yang dimiliki oleh konstitusi Indonesia juga memiliki banyak kekurangan. Sebagai contoh, kita dapat menemui political involvement and political interest dalam proses-proses amandemen konstitusi. Political involvement and interest yang mungkin terdapat di dalam proses amandemen dari suatu konstitusi mungkin terkait dengan berapa lama suatu presiden dapat menjabat, dan lebih utamanya seperti yang disinggung tadi adalah mengenai pasal 33 dalam konstitusi kita yang berhubungan dengan natural resource. Pertanyaan saya adalah bagaimana cara mencegah political involvement and political interest dalam proses constitution making? Mungkin itu saja.
Tunggu sebentar, masih saya catat ya.
I already know that it's quite a question. I'm yet waiting for the translation, and already I'm impressed with the question.
Selagi saya mencatat, is there any question?
That's either a very good sign or a very bad sign. Either I was very clear or not at all.
Yes, please. Yeah.
Baik, yang pertama adalah terkait dengan hukum adat di Indonesia, adat law. Itu sudah ada sebelum konstitusi ada, dan itu clear masuk di dalam undang-undang dasar. Tapi perlu Anda ketahui bahwa Sascha, dalam pembentukan undang-undang dasar itu juga ada completed, yaitu terkait dengan hukum agama, yaitu ada perubahan di pembukaan. Nah, saya ingin tahu pendapat Anda terkait kondisi di Indonesia kaitannya dengan pembentukannya terkait dengan hukum agama. Karena tadi Anda hanya bicara soal hukum adat dalam pembentukan konstitusi di Indonesia. Oke, yang kedua, di dalam teori konstitusi dikatakan bahwa perlu ada yang namanya review konstitusi. Review konstitusi. Nah, di Indonesia itu ada perubahan konstitusi, ada beberapa tahapan, 1, 2, 3, dan terakhir ada amandemen. Amandemen 1, 2, 3. Nah, menurut pendapat Anda, setelah amandemen perlu nggak review? Atau review dulu baru amandemen? Karena nggak clear dari penjelasan Anda tadi. Yang ketiga, sorry. Wait, sorry.
Yang kedua tentang
review konstitusi. Kan dia perlu amandemen, review. Nah, yang ini saya tanyakan, Indonesia kan review Mas Sukri. Ya, 1, 2, 3. Di mana posisi review itu? Setelah amandemen atau sesudah amandemen? After. Oke. Masih ada? Bisa lagi? Nah, Betri?
Yes.
Oke, terima kasih. Oke. Ya, terakhir adalah terkait dengan perkembangan terbaru Omnibus Law. Terkait dengan perubahan yang dipakai, yang diterapkan di Indonesia dari civil system menjadi common law system, di mana Omnibus Law posisinya bagaimana secara konsep? Dia masuk civil system atau common law system?
Omnibus Law.
Ya, masuk di dalam sistem mana? Di Indonesia. Karena dengan adanya sekarang penerapan di Indonesia. Oke, itu aja.
Masuk ke dalam
civil system atau common law system? Oke? Clear. Terima kasih. Thank you.
Let's hope I can answer some of that. We'll see. Otherwise, I gladly refer the question to you, Pashukri, or to Paradian, who is the expert on Indonesian constitutional law. So he's already running away. All right.
It's kind of busy here. Okay, Mbak.
Thank you. Sascha, welcome. I'm interested with your idea about democratic constitutionalism. For democracy constitutionalism, we need an independent of judge. Here, I want to know your idea about independent of judge. Now, today, the recruitment of special for a constitutional judge is near with politics, like that. Now we study about the independent of judge in legislative process.
Yeah.
This is number one. For number two is judicial review legislative process. In the making of law, the making of a regulation. We have UU KPK, UU Omnibus, UU IKN, with not only more 3 months, here like this. We didn't have a specific and about the judicial of process, the making process of regulation in legislative. Not accurate again. If we're talking about democracy in legislative, we must can review on constitutional court.
Yep.
We have 2 complexities like this, independency of judge, and now is talking about judicial review of legislative process. It's not substance in process on DPR. Okay, thank you, Sascha.
Sorry, so what is the question? Or you have this dari pertanyaan atau komentar?
No, I want this idea about problem hari ini. Konstitusi kita tidak punya akurat, sistem yang akurat untuk judicial proses yang ada di DPR. Undang-undang Omnibus cuma 3 bulan. Dan itu, we cannot to guarantee that is democratic, true or not, this is legal or not, like this. Okay.
So I start with those, so to give you some time to translate the earlier ones.
Yes, okay.
Okay.
Thank you, Sascha.
So thank you very much for your question. I didn't catch your name, I'm sorry.
Najida.
Ms. Najida.
Yes.
Thank you very much for these questions. Now, both are, of course, very contentious problems. The independence of the judiciary is crucial. It is, of course, not only crucial for constitutionalism, but crucial for the functioning of the judiciary in a state which adheres to the rule of law itself. The independence of judges is crucial. But how exactly to bring about judicial independence? You could say, as some systems do, let's appoint judges, or judges of a certain importance at least, like federal judges in the US, let's appoint them for life and make them very, very hard to oust, to bring out of office. But of course, that carries with it also some difficulties of its own. First, appointments for life can be a very, very long time these days. Second, appointments are often political processes, as you mentioned yourself. Very often there's proximity, closeness between the judge that is appointed and the political party or person who is ruling at a certain moment. So therefore my personal favorite system, if you like, or the system that I would propose is one that has several components. First of all, I would not, in principle, propose appointments for life, but appointments for a limited but not too short number of years. So if you look at, for example, and I think that's a relatively good calculation of the term of office of constitutional judges in the German Constitutional Court is 9 years and can be renewed once. So the total maximum is 18 years. So, but 9 years is the principal term in office. Also, there should never be, in such important matters such as constitutional review, this should be done not by a single judge and also not by too small a college of judges, 3 or so, but by a relatively large college. And the judges shouldn't be appointed and reappointed all at the same time, so that there is both evolution over time and also fluctuation, but again, not at too short intervals. So there should be both continuity and the possibility for change. Because whatever system for appointment you choose, there is always some sort of political component in there. In the US, federal judges are appointed by the president with the approval of the Senate. So if you have a conservative president and a conservative Senate, for as long as the presidency lasts, they can appoint conservative judges, and these judges will sit for life. So they can basically rule on the political leaning of the federal courts for a very, very long time. That is not ideal. So I think it is useful if appointments are depoliticized as much as possible. In some systems we see that judges are appointed by different parliamentary chambers, for example, for a limited amount of time, and on the basis of proposals drawn up by judicial colleges. So they don't pick them at random from, whatever jurists seem to be about, who are political friends of the politicians, but they must pick them from a list that the judiciary has drawn up. Now, I understand that some people criticize this as not being very democratic, because the judiciary is an elite, and why should the elite draw up these lists? Yes, but you have to always weigh certain items of importance. And I think qualification is one, and that the judiciary is probably better at judging qualification than the politicians are. And sort of it usually rules out the extremes if you do it this way. And then appointments should be done by different institutions. So for example, if you have constitutional judges appointed not by the president or not by one of the parliamentary chambers, but by both. So one chamber gets to appoint one judge, one other chamber gets to appoint one judge, and maybe the president gets to appoint a third one also, like they do in France. this, at least you spread the possibility of political influence across various actors. That might be an idea. Of course, there's no blueprint. I cannot tell you this is the right system, because what the right system is depends on a lot of circumstances that differ from one country to the next. But what is important is that you do everything and anything to limit the political power on appointments, because otherwise it will be abused. So I'm quite in favor of having the necessary checks. And one of the, even if it fails, then still you have the fallback option of having a limited term limit, the limited number of years, and not appointment for life. So I think appointment for life is generally, today, not a very good idea anymore. You have to imagine when the US introduced this system 200 years ago, life was a lot shorter than today. So when a judge would be appointed in their late 40s in the 19th century, that would mean they would sit for a maximum of, I don't know, 15 years or so, because usually people died relatively young. Today, if you are appointed at 40 and you live until 95 in relative good health, then that's a very, very long time. So I would suggest no life appointments and spreading political power. The second one of your questions, yes, I do believe that the power of constitutional review should extend not only to the content of a law, but also, if I hope I understood your question correctly, should there also be constitutional review on grounds of procedure for lawmaking? And I would generally say yes, because procedure is an important factor in the creation of legitimacy for legislation. If legislation is created without competence, which is normally the contentious issue in procedure, then it lacks at least democratic legitimacy. Of course, we can go into legal philosophy and argue that there are also other sources of legitimacy, but at least the democratic chain between, you know, the people electing representatives and the representatives legislating is broken if procedure is not observed. So therefore, yes, there is a strong argument for political review also on the basis of procedure. And we do see that lack of competence is one of the main arguments in constitutional rulings of unconstitutionality by US Supreme Court, the German Constitutional Court, and many of the constitutional courts across the board. So from my side, that would be a clear yes in favor of that option.
We have another 3 questions, Sascha, and I have been translated on this laptop, so I'm going to give you this list of questions.
Oh, thank you very much.
Yeah, so it will be easy for you to understand the question.
So, Mr. Randi, Indonesia's constitution is complicated but also flexible, and it can be amended. How to prevent political intervention and political interest that affect constitutional amendment? Now, first of all, it is very important to understand that, like all lawmaking, constitution making is a political endeavor. So the question is not to limit the influence of politics as such, because it is the task of politics to make law. I think what you're really asking, correct me if I'm wrong, is how do you prevent the undue influence of certain particular interests? So basically, how do you prevent the influence of corrupt politicians in making these things? Because political influence, it is a political thing. And politics is not a, is not a bad word in itself. But how do you limit undue influence of groups? Well, I think that is a very, very hard question to answer. And we see that this is problematic far beyond Indonesia, and one construction side, as I would say, that we see in many jurisdictions nowadays is how to control lobby, how to control the influence of well-funded organizations such as the super PACs in the US or such as the lobby organizations in Brussels and the European Parliament. So I would say have good lobby control legislation and have, probably even more important, have good legislation on the transparency of who funds political actors. Where does the money for political campaigns come from? Are there industries that fund politicians and their campaigns? Are there religious groups that fund politicians and their campaigns? You cannot really, you can prohibit it, but it's very ineffective nowadays because funding can also be, very indirect. For example, the Koch brothers in the US very famously often do not fund, they also fund politicians directly, but they also fund people who make Facebook ads and WhatsApp groups, which is not prohibited because you have freedom of speech. So you can't ultimately prevent people from, with money, to issue opinions which then influence political processes. What you can do is make everything that relates to politics strictly transparent. So if anybody gets money from anybody else, make it public. I think that is probably the most important and effective thing. It's not a panacea. It's not something that solves the problems of the world, but it goes a great length to solve things. Controlling lobbyism goes in the same direction. Make it transparent. Don't prohibit politicians from speaking to lobby organizations, because lobby organizations also have positive roles because they inform politicians about what is going on in the industries and what is going on in the economy, for example. And there are also civil society lobby organizations like fundamental rights groups. But when politicians talk to lobby groups, make it public. When politicians get out of office and get a job with a company, make them wait for a couple of years first and make it public. That the new PR manager, government affairs manager of Facebook used to be the Minister of Information before. Something like this should be public information. So make legislation to make these processes transparent. Still, I agree, it is a very, very difficult thing to do. 3 questions from Busiti. Customary law existed before the Constitution was made. However, there are also religious laws recognized in the Constitution. What is your opinion on that? Now, first of all, what I said in the lecture already, the idea of constitutional reference to Adat law, and I think we can extend that to religious law. So the idea that the Constitution should not only recognize, but in many instances defer to customary law. It is true that this is Indonesian particularism, but it is not true that this principle is originally an Indonesian idea, because the person who came up with that this should be the Indonesian way was a colonialist. Van Vollenhoven basically came up with the idea of this Adat. Now, of course, the content of Adat law itself was always around, but the idea that Indonesia cannot have anything else but a constitution that defers to Adat law is an imported idea. So we should keep that at the back of our minds. As I said in the presentation, there is a limit to how far the constitution can defer to customary and also to religious rules without becoming unconstitutionalist. So you can have a constitution that says all kinds of things, but if you want to continue subscribing to constitutionalism, so that triangle of democracy, fundamental rights, and rule of law, that can only go so far, because there needs to be, at a certain level, unity of fundamental norms. So neither religious rules, nor Adat rules, nor anything else can go against the fundamental norms, because otherwise they aren't fundamental anymore. They also cannot go against democracy and minority protection and all these kinds of things, and there needs to be a certain unity. Does that preclude reference in the law to regionalism or to local adat within this spectrum. No, not at all. And there Indonesia is also not alone. Other countries have that too. And I think it is a useful thing in a pluri-ethnic and pluri-religious state like Indonesia to incorporate all kinds of local circumstance, but only to a certain degree. And the boundary is where constitutionalism would be, so the boundary is dictated by constitutionalism. If you have deference in the constitutions to rules that transgress, violate, or upend fundamental rights, well, then your fundamental rights are gone. Then they become ineffective. So therefore, that would be a boundary, and that goes for any type of origin of rules, whether they be customary, adat, religious, or positive, wherever they come from. So maintain this reference. I don't see a problem as long as it's within that spectrum. Would be my answer. Otherwise, it just becomes a logical non sequitur to have constitutionalism and adat law at the same time. What is the order of reviews and amendments of the Constitution? I don't understand that question. Could you explain your second one once again, the one about reviews and amendments of the Constitution?
Does the concept say? What's the normal way?
So,
The sequence of.
Okay. Right. Okay. So they're separate. Constitutional review is the review of lower norms against higher norms. Judges or whoever is tasked with it, so sometimes it's councils or certain types of tribunals or regular judges, depending on your system, they check whether statutory law or government action or government regulation is in line with a constitutional rule that already exists. And if they say no, then usually they have to be, sometimes they can give the political actors time to amend it, but the normal way is that unconstitutional norms are simply quashed in most systems. Amendment can happen as a result of constitutional review, but it can also happen as the result of political will. So there's no strict sequence between review and amendment. Amendment can be the consequence of review, but it can also be the consequence of, political majorities shifting or something like this. There's no strict sequence between the two. Third question: the omnibus law, conceptually, does it belong to the civil law or to the common law system? Very difficult. First of all, I'm not an expert on the precise. I have a rough idea of what the omnibus law does and what it is. It is not typical of either. I would say it is not typical of either the common law or the civil law system. Indonesia is a system in the civil law tradition, and the way that this law is being made is a civil law legislative process, but it is unusual because because it covers a lot of ground, and I think one of the criticism is that the process is insufficiently specific and precise to all of the little items that fall under it, right? So that is part of the problem that many people have with it. I don't think it's a question of system. I think it is a question of procedure. The procedure for making this. So I would a more specific answer. I think I would relay to the Indonesian law experts and the legislative experts. I think the two questions by Punajida I have already answered, and then we have a question from the chat in YouTube from Miss Marsha. In regard to the second, can I have my slides again, then I can see it? In regard to the second sub subarticle of Article 33 of the Constitution, currently we're using cost recovery. Operator will be paid back by the state for operated fund 100%, and gross split, sharing operation funds financing system for oil and gas application purpose. Can we declare that the natural resources controlled by the state is already applied? Wait. So let's to see what Marcia is talking about there, the second subarticle. Sectors of production which are important for the country and affect the life of the people shall be under the powers of the state. Now, yes, what you described, the problem, the legal question which you describe is, I think, the legal question that was also being discussed or at the center of the two times that the Mahkamah Konstitusi has considered this article, and they came to different results. So my answer here is, I don't know if we can declare that. I think that is a possible opinion, but I think this phrase, under the powers of the state, can mean different things. And which it means exactly depends on a number of factors. First of all, does the state mean the government? So does being under the power of the state mean that the government has political freedom to do with the management of natural resources as it pleases, or that the legislator has freedom to legislate on the management of natural resources as it pleases, or are there constitutional limits to that? So can they basically make a law as as a state organ? Can the state organ legislate that you can privatize this, or that you can give this payback scheme which you are outlining in your question? It is one possible view that this is the meaning of being under the power of the state. Another interpretation is that in order to remain under the power of the state must create agencies which perform these tasks themselves. So the day-to-day management and the day-to-day exploitations. What the correct view is, I cannot tell you, and frankly I think from a standpoint of legal logic, nobody can, because the phrase is open. So it is up to the constitutional judges, if it comes to litigation here, and otherwise the interpretation of political actors to interpret that phrase. In the long run, since this is becoming contentious and remaining contentious over the decades, I believe that it would be wise to have, in order to create stability and consensus, to have a replacement of Article 33 and to explicate both the principle in subparagraph 1, what does the kinship system really imply, and also explicate the principle enshrined in subparagraph 2, what does power of the state really imply? Because both are open, we don't know. Of course. Thank you very much for your questions. By the way, these are great questions.
Do we still have any questions or comments? Masih ada pertanyaan atau komentar? Yes, Pak Radian.
You mentioned that Netherlands doesn't have a judicial review, yeah? So maybe you can explain to the students or to all of us that how citizens have control to the product of parliament in the Netherlands.
Yeah.
Thank you.
So the Netherlands is a very strange animal indeed when it comes to this. There are only two types of system within the constitutionalism world. So inside the spectrum of democratic constitutionalism, which do not have constitutional review at all, and the one is the UK system, where you have parliamentary sovereignty and constitutional review is therefore ruled out. And you have the Netherlands, where Article 120 of the Constitution explicitly says, literally says, the judge shall not enter into the constitutional review of legislation. That's a key phrase, legislation. So the Netherlands can't do what Germany does all the time, judges quashing legislation for reason of unconstitutionality. But the Netherlands have created several workarounds for this. First is Article 120 is strictly limited to what the Dutch call wetten in formele zin, statutes in formal sense, which is limited to acts of parliament. That means that all kinds of lower level regulations, provincial regulations, municipal regulations, ministerial regulations, administrative measures, acts of the government, all of these things can be subject of judicial review, also against the constitution. Only statutes, so acts of parliament, cannot. That's an important limitation already. By the way, that's also true for the UK system. So also there, only acts of parliament are not subject to judicial review. Second, and more interestingly for the Netherlands, they have created a workaround especially for fundamental rights, because Article 93 and 94 of the Constitution provide that when legislation, so acts of parliament included, are in contrast or in violation of rules that stem from self-executing international treaties, then judges can leave these acts of parliament out of consideration or out of application. What does this mean? The Netherlands is party to a lot of international treaties, and very importantly, many of them relating to fundamental rights, such as the European Convention on Human Rights and Fundamental Freedoms, the International Covenant on Civil and Political Rights, Convention on the Rights of Disabled People, many international treaties which contain specific individual fundamental rights. Now, also international treaties which contain other rules which have nothing to do with fundamental rights, but these are the most important ones for Article 94. Now, whenever an act of parliament makes an encroachment on this area, fundamental rights, any judge in the Netherlands, not just the Supreme Court, but any judge can basically test the validity of national law, including acts of parliament, also including the Constitution itself, which doesn't formally happen, but it's possible, against these treaty norms. And this is basically a replacement for what happens frequently in constitutional review in countries like Germany. Often the reason for constitutional review in Germany, for example, is the violation of a fundamental right. I'll give you an example. After 9/11, Germany made a law that allowed the Minister of Justice to order that a plane that is hijacked by terrorists can be shot down, even if there's innocent people on the plane. The Constitutional Court said, no, that's not possible because it violates the right to life of the people on the plane. So you can't do that. You can't make that law. The law is unconstitutional and the law has to go. In the Netherlands, there's no Constitutional Court and the Supreme Court couldn't have said this. However, they could have said this, not on the grounds of unconstitutionality, but on the grounds of violation of Article 2 of the ECHR, which also enshrines the right to life. So for fundamental rights, the Netherlands basically doesn't need constitutional review because they do treaty review instead. Where it becomes difficult is the thing that Bunajida has mentioned, review of statutes on the grounds of procedure, because procedure is never mandated by international treaties. And if the national legislator were to make a law that it is for some reason incompetent to make, but they still make it, then there is no possibility of review against that. And that is a serious problem sometimes. So Article 120 is in a sense more limited than it sounds, because you have the option of treaty review for fundamental rights, but it is still a very important feature and limitation in comparison to other countries' systems.
It's 12 o'clock now, sudah jam 12 siang. kita lebih cepat. We are sooner than we expected. Kita lebih cepat dari jadwal yang telah ditentukan. We're supposed to end this conference at 1 p.m. but I think we going to end up this discussions on this lecture. Final chance. If you still have any comments or questions, audience? Nay? No, we say nay in Dutch. No, for no, yeah, nay. Nay? Okay, so setelah kita mendengar dari Sascha, after we learn and discuss in Q&A sessions, dalam questions and answer sessions, maybe we have to hear a closing statement from Sascha today, please.
Thank you very much again for the great opportunity to speak before you today. I hope that this was interesting to you, and that you had the possibility to learn something from the exchange that we had. I think, building on what I said in the presentation, again, as a comparative constitutionalist, what you see in a lot of literature, especially a lot of older literature, but it still happens, is not only that even comparativists like myself are often quite ignorant about many systems outside the usual suspects of the US and Germany and France, which is not so strange because you only have capacity to study so many systems, and you're limited by language and by all kinds of things, so that's rather normal. But also there's a lot of paternalism, I think, in the literature still when it comes to systems like Indonesia, but also that of many other countries that are not part of the traditional canon of systems that are studied. And I think this is wrong. Of course, there's only so much that comparativists and constitutionalists can do, but I think there should be a broader exchange between countries and between scholars, including from polities like Indonesia, but also including many others. Certainly, since we are all within the same constitutionalist spectrum. And therefore, I really appreciate this possibility for exchange with the scholars in the room, but also with the students in the room. And I think this is highly important, and it should be continued. But this paternalism, it also exists in the ideas that are often purported. For example, this idea that the Indonesian system and these references that you have to adat law, for example, are a provincial or a parochial thing. It is an unusual thing, at least the extent to which Indonesia does this, but it is also something that is as deeply rooted in the history, in the context, and in the specifics of the Indonesian constitutional history. As is, for example, the lack of constitutional review in the Dutch constitutional history, or the emphasis on human dignity in the German constitutional history. These are just peculiars and not provincialisms. And therefore, I think the exchange is extremely important but it should be held at a level. And I hope I had the possibility to contribute to this today, and I hope we continue building this dialogue, and I'm very happy in a very short while to be receiving a number of colleagues from a number of Indonesian universities in the Netherlands to continue this exchange. Thank you very much for having me.
Okay, Ingrid, you may take the silakan untuk kembali mengisi acara.
Check. Well, thank you, Shukri Hidayatullah and Sascha Hardt. So we have participated in this panel with the theme Constitution Making, Concepts, Context, and Complexities. May it bring benefit to all of us. So ended the guest lecture with the theme Constitution Making, Concepts, Context, and Complexities, Faculty of Law, Mulawarman University. I would like to express our deepest gratitude to all those who have made today's event a success. May you always be healthy. And on behalf of the presenters today, apologize if there are words that are less pleasing. Thank you again from us, Faculty of Law, Mulawarman University. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Om Santi, Santi, Santi Om.
Surga lestari abadi, lebih bagai surga. Lebih bagai surga lestari abadi. Hear the sound of a string melody, singing a song of the glory land. People are dancing with hornbill feathers, smiling faces and brotherhood warmth. Surrender ourselves and pray with our heart. May peace prevail within every soul. Let's stand up and put our hands together as the guardians to protect our land. Through generations